Our first discussant is Dr. Sarah LOTHIAN, and Sarah is a lecturer and academic barrister at the Australian National Centre for Ocean Resources and Security at the University of Wollongong. Of her many distinguished accomplishments, the one I'm going to highlight, because I've told you everything is in the book, but there's always one that I want to point out, at least for your attention. And Sarah is probably saying, which one is it now? It's Sarah's book, Marine Conservation and International Law, Legal Instruments for Biodiversity Beyond National Jurisdiction. This was published in 2022, and Sarah, I have a little star here, says must buy. And for all of you in the audience, star now, must buy. And so I'm going to tell you what's in the book in introducing Sarah. This provides a comprehensive assessment of the BB&J negotiations and situates those negotiations against a broader historical context by examining how the Grotian concept of freedom of the seas continues to have significant influence on the conceptualization of contemporary ocean problems and solutions to them. Sarah's book analyzes each of the 4 elements of the BBMJ package deal and proposed potential areas of compromise on the more contentious negotiating issues. So we're going to hear some of this in her discussant. So Sarah, I know you're going to take the podium. We women like to do things a little differently, so please head up there.
Thank you, Judge Brown, for that kind introduction. And I wasn't plugging my book at all. I also want to thank the organisers for inviting me. This is my first time in Seoul, and I couldn't have asked for a more warm welcome, so thank you very much. It's also an honour to share the panel with my dear friends and colleagues. And I hope to build on some of the comments and really reflective things that Ligia and Harriet have had to say. In particular, I'd like to use my time as a discussant to really drill down and highlight the innovative cooperative mechanisms and tools that we now have in the BB&J agreement for capacity building and technology transfer. And I'd also like to turn to the important role that I think international cooperation will play in making sure that those mechanisms work effectively in practice. So, as greater scientific knowledge and research of areas beyond national jurisdiction is critical to ensure the long-term protection of marine biodiversity, it was acknowledged very early on in the BB&J negotiation process that innovative mechanisms would be required to promote cooperation and coordination for marine scientific research, not only to improve our understanding of the deep ocean environment, but to facilitate better informed policy and decision-making. BB&J negotiators also recognised that these innovative mechanisms would need to be underpinned by a renewed sense of and duty to cooperate. Oh, my slide's not working. Okay. So, as Harriet mentioned, we didn't have to start from scratch when it came to the issue of capacity building and technology transfer in the BB&J negotiations. The framers of UNCLOS, as we've heard, recognised the differing ability of states to benefit from the ocean, and they were keenly aware of the need for capacity building and technology transfer, which, as Harriet talked about, is evident in Part 14 of the Convention. Although Part 14, and I agree with you, Harriet, does set out some ambitious aspirations, I am one of those academics that have always been a bit frustrated, and I've referred to it as the sleeping giant of UNCLOS. Part 14 provisions have always had enormous untapped potential, but have remained dormant, inactive and underutilised since the adoption of the Convention. And really, I see the main problem as being that Part 14 obligations were severely watered down during UNCLOS negotiations in an effort to appease the interests of a key bloc of developed states. And as a result, many of those key provisions were shrouded in flowery language rather than strict legal obligations. So if we were just to take Article 266 of UNCLOS as an example, Article 266 sets out 3 overriding obligations for states, namely to cooperate in order to actively promote the development and transfer of marine science and technology. We've also got to promote the development of the scientific and technological capacity of states, as well as to endeavour to foster favourable economic and legal conditions for technology transfer. Now, while developing states sought strongly worded commitments in Part 14, including in Article 266, and earlier drafts of these provisions actually contained much stricter language, these provisions were unfortunately watered down. And what we ended up with in Part 14 was what I would call a series of best effort obligations, where the verb shall, which is usually indicative of imperative duties and obligations, is juxtaposed with vague commitments such as promotion of objectives and endeavouring to take action. So those Part 14 provisions were not really formulated as strict legal obligations, but really dictate a certain standard of behaviour and are more reflective of policy goals, and this, I think, is what's granted states considerable latitude when it comes to their implementation. And this was actually one of my greatest fears during the BBNJ process, was that we would end up with an instrument that made all the right noises in terms of its aims, aspirations and intentions, but would be severely lacking in substance with watered-down tools, approaches and mechanisms unable to effect any real change. So in other words, we could have ended up with an instrument with bark but no bite. So the development of the BBNJ agreement offered a timely and much-needed wake-up call, and really it offered an opportunity to revitalise and strengthen that existing capacity building and technology transfer formula that we already have enshrined in UNCLOS. So while some delegates were keen to see Part 14 simply incorporated mutatis mutandis into the new instrument, merely revisiting the existing formula in UNCLOS and underscoring the importance of capacity building and technology transfer was never going to be enough and would not have provided the necessary transformation required by developing states. So instead, just like Ligia mentioned, just with the other elements of the package deal, BBNJ negotiators had to compromise, and we had to find that elusive sweet spot for capacity building and technology transfer, one that would require enough effort from states to generate real benefits, but not efforts that are so costly that states elect not to participate in or implement the agreement. So the question is, does the BBNJ agreement go far enough to wake the sleeping giant of UNCLOS from its slumber? I'm confident it has for 2 reasons. Firstly, the BBNJ agreement now contains key mechanisms, as Harriet alerted us to, that enhance the implementation of existing UNCLOS requirements. And 4 in particular really stand out to me. The first is the formalisation of a clearinghouse mechanism. The second is the enhancement of the data sharing infrastructure. The third is the incorporation of that innovative funding model. And lastly, and I'm a fan too, Harriet, the mechanism that we now have for monitoring, review and follow-up, which was much needed. The second reason I'm confident that the BBNJ agreement can wake the sleeping giant of UNCLOS is mainly due to the fact that the instrument strengthens and revitalises Part 14 by underpinning its obligations with a meaningful duty to cooperate. So whilst UNCLOS is considered to be a monument to international cooperation in the treaty-making process, it doesn't actually specify the legal content of the duty to cooperate. And Part 14 of UNCLOS provides us with an excellent example. The duty to cooperate is considered the cornerstone of the normative framework for capacity building and technology transfer in Part 14, as it's referenced either directly or indirectly in almost all of its provisions. Article 266, for instance, requires states to cooperate in order to promote the development and transfer of marine science and technology. However, the content and nature of this obligation to cooperate was not elaborated upon in UNCLOS and has remained uncertain. And this has led to a failure of states to adequately implement and enforce those cooperative duties in Part 14. So the development of the BBNJ agreement really presented an opportunity to define and operationalise the duty to cooperate in order to enhance and strengthen existing UNCLOS requirements. So for example, we now have provisions like Article 41 of the BBNJ Agreement, which sets out an explicit duty for state parties to cooperate in capacity building and the development and transfer of marine science and technology to assist developing states in achieving the objectives of the instrument. And I don't think we should underestimate the importance of international cooperation when it comes to capacity building and technology transfer. International cooperation really lies at the heart of the BBNJ Agreement, and I believe it'll be the linchpin to its successful implementation and operationalisation, particularly when it comes to making sure that those cooperative mechanisms and tools included in Part 5 of the instrument can work effectively in practice. The BBNJ Agreement sets out an explicit obligation on states to cooperate, and then it goes further. It elaborates on the content and modalities of this obligation, which Harriet has taken us through. International cooperation is not listed in Article 7 of the BBNJ Agreement, which contains our general list of principles and approaches to guide state parties in achieving the objectives of the instrument. Instead, what we have now is Article 8, which is completely devoted to the principle of international cooperation. And this is really significant as it reinforces and reiterates the essential need for cooperation in achieving the objectives of the BBNJ Agreement, but it also serves to set that principle apart as one that underpins the instrument as a whole and is therefore critical to its overall success, including those provisions in Part 5. The Part 5 provisions should always be read in conjunction with Article 8 of the BBNJ Agreement. Article 8 establishes that primary obligation of states to cooperate for the conservation and sustainable use of BBNJ and provides that in seeking to achieve the objectives of the agreement, states should strengthen and enhance cooperation within and promote cooperation among relevant legal instruments, frameworks and bodies. So Article 8 is emphasising the importance of cooperation at all scales. And again, this is really significant as cooperation has been the Achilles heel of the existing international law framework for areas beyond national jurisdiction. But now, under the BBNJ Agreement, state parties will be required to cooperate to assist developing states in achieving the instrument's objectives through capacity building and technology transfer. And this cooperation is to take place at all levels and in all forms, including through enhanced cooperation and coordination with existing international resource and environmental governance regimes. So given the highly fragmented and disjunctive framework that governs areas beyond national jurisdiction, Article 8 of the BBNJ Agreement is unusual in that it recognises that the BBNJ's agreement's success will depend on implementation not only by states under whose jurisdiction or control activities take place, but also existing governance organisations and bodies that regulate activities beyond national jurisdiction. The last part of Article 8 is also important for our discussion as it specifically relates to marine scientific research and technology. International cooperation in marine scientific research has been pursued since the turn of the 20th century and is particularly important in the BBNJ context. And as we've heard, research in areas beyond national jurisdiction relies on skilled individuals, appropriate infrastructure, and significant financial resources. But as many countries lack the capacity to participate in this type of research, they can really miss out on those benefits to be derived from the discovery of new ocean life, habitats and processes. So Article 242 of UNCLOS already sets out a general obligation incumbent upon states and international organisations to promote international cooperation in marine scientific research, while we've also got Article 266, which promotes the development and transfer of marine technology. So in order to support the objectives of the BBNJ Agreement, Article 8 is really reinforcing these existing UNCLOS provisions by obliging states to promote international cooperation in marine scientific research and in the development and transfer of technology. And again, this cooperation is really to take place at all levels. We're talking societal, institutional and individual, as well as in all forms, including through collaborative arrangements and partnerships with relevant stakeholders. And in giving effect to Part 5 of the agreement, state parties will also be required to give full recognition to the special needs and requirements of developing states. And here I think it's really critical to underscore the importance of regional cooperation and building a network of capacity building partners. A network of regional partners could share knowledge and find areas to collaborate to produce project synergies. It would also help to avoid duplication of efforts and obviously maximise efficiency and efficacy. So aside from setting out a clear and unequivocal duty to cooperate, the BBNJ agreement supplements this duty with cooperative mechanisms and tools that have been intricately woven throughout the text of the new instrument and underpin each element of the package deal, including capacity building and technology transfer. And again, these cooperative mechanisms and tools really help to fill in those gaps left behind in Part 14 of UNCLOS. So for example, a main flaw of Part 14 is that its obligations have always been expressed in general terms and have left out details on how, that important question that Harriet said, that how question, how capacity building and technology transfer can work in practice. So the BBNJ agreement recognises that capacity building and technology transfer is a critical cross-cutting element, and it will be required to support developing states in achieving the objectives relating to the other three elements of the package deal. So in other words, cooperation when it comes to capacity building and technology transfer will be a prerequisite for developing states to reap the full benefits of the other elements of the package deal and is therefore vital to its overall success. So take, for example, the issue of marine genetic resources at deep-sea vulnerable marine ecosystems. We know that very sophisticated and expensive technologies would be required to reach deep seabed environments and sample these organisms. But as Harriet and Ligia have alerted us to, this technology is currently in the hands of only a few states. Access to relevant information and data also tends to be expensive and limited to academic and scientific institutions in developed countries. So the BBNJ agreement really attempts to bridge this gap between North and South by elaborating upon the types and modalities for capacity building and technology transfer. And as Harriet has mentioned, Article 44 and Annex 2 of the BBNJ agreement sets out a non-exhaustive list of capacity building and technology transfer activities and initiatives. And we've also got Articles 42 and 43, which now help us by setting out necessary modalities. The establishment of the clearinghouse mechanism under the BBNJ agreement, I think, will also be a very important tool for implementing these capacity building and technology transfer provisions. And while the specific modalities of the clearinghouse will be determined by the Conference of the Parties at a later date, we do know that it has been tasked to perform a wide range of functions. One in particular is that it will serve as a centralised platform to enable parties to access, provide and disseminate information with respect to data, marine scientific and technological knowledge, as well as research relating to those other elements of the BBNJ package deal. We also know that the clearinghouse will serve in facilitating, as Harriet mentioned, scientific and technical cooperation within and between state parties, as well as relevant stakeholders, and provide links to other relevant global, regional, national and sectorial clearinghouse mechanisms, as well as potential gene banks, repositories and databases for the exchange of information. And of course, this in turn could really strengthen cooperative links between existing organisations and bodies to foster collaborative initiatives and research projects among states. So the BBNJ agreement thereby recognises that cooperative efforts should really manifest themselves in different forms at various levels and amongst a diverse range of stakeholders and actors. And as information concerning deep-sea biodiversity is currently located in locations all around the world, the clearinghouse will also provide an invaluable practical tool when it comes to enhancing the data sharing infrastructure and ensuring equitable access to that data and information. Significantly, the BBNJ agreement has adopted what I would call a hub and spoke network model for its clearinghouse, which will serve as a central hub overseen by the Secretariat and then potentially provide links to other clearinghouse mechanisms and other gene banks, repositories and databases. An obvious one being the Ocean Biodiversity Information System. And I note that the National Marine Biodiversity Institute of Korea has recently rejoined the OBIS network and will serve as the national OBIS node. So just briefly, another important point which I agree Harriet alerted us to is the innovative funding model that we now have under the BBNJ agreement, and a lack of financial resources has really been a real impediment to capacity building and technology transfer. The financial mechanism established under the new instrument is there to assist developing states in implementing the agreement, including through the provision of funding in support of capacity building and technology transfer. And in particular, the Special Fund and the Global Financial Environment Fund are to be specifically utilised to fund capacity building projects, including activities and programs on the conservation and sustainable use of BBNJ. So again, the success of this financial mechanism will rely on international cooperation, and this will be necessary in order to support more meaningful participation of parties in the implementation of the BBNJ agreement. And as I mentioned before, I'm a huge fan of the monitoring, review and follow-up mechanism that we now have in Article 45, because this has also been a significant gap that we had in Part 14 of UNCLOS. We were not able to measure the success of capacity building and technology transfer efforts. So now, under the authority of the Conference of the Parties, the Capacity Building and Transfer of Marine Technology Committee will now oversee the delivery and effectiveness of Part 5 obligations, and parties will also be required to submit reports which will hopefully be made publicly available in the interest of transparency. So it's clear that the BBNJ agreement really does revitalise and strengthen Part 14 of UNCLOS by setting out the modalities and cooperative mechanisms for the multilateral facilitation of capacity building and technology transfer. And importantly, all of these modalities and mechanisms are underpinned by a duty of cooperation. International cooperation was seen as a prerequisite to reaping the full benefits of UNCLOS and was considered critical to its overall success. And arguably, I would say the same is now true for the BBNJ agreement. The drafters of the BBNJ agreement have done a wonderful job in carefully and intricately weaving duties of cooperation and cooperative mechanisms throughout the fabric of the text. And I really think that the BBNJ agreement should therefore be seen as a significant milestone in the institutionalisation of international cooperation. And I think it's important to recognise and acknowledge the instrument's framework for cooperation and the specific mechanisms and techniques it utilises to strengthen, enhance and foster coordination, coherence and harmonisation between and among states, as well as existing governance organisations and bodies, particularly when it comes to capacity building and technology transfer. Thank you, and I look forward to your questions.
Well, a big thanks to you, Sarah, and thanks to all of you. I mean, I'm about to have one more discussion, but before that, I would say that you made the point about whether or not the BBNJ agreement may wake the sleeping giant, and that actually spurred me to make a confession that when I used to be involved in the negotiations in terms of the region, our inputs, and so when the agreement was adopted, I got this WhatsApp message, "We did it, Kathy," about 15 exclamation marks. So I quickly downloaded the draft agreement and I read it through page by page except for one chapter. And when it was adopted in the UN General Assembly, I said, we'll have to reread it because, the changes, technical changes, and I read it page by page except for one chapter, and I've had to refer to it numerous times, page by page, except for one chapter. And I'm very glad that I was asked to moderate this session, because it would have been terrible had I never read that chapter. And I think that it's really great why we have had such a detailed presentations, because I don't think I'm the only one, if we all confess the truth, that has not read that particular chapter. So our final presentation this morning is from our discussant, Ms. JUNG. And what am I going to highlight about her distinguished career? Well, Ms. JUNG is from the Ministry of Foreign Affairs, and she has worked as an attorney specializing in maritime law and international transaction. And she's not only from the Ministry of Foreign Affairs, she's from the International Legal Affairs Division, and she's not only from the International Legal Affairs Division, but she's the director of that division. And for present purposes, I think what is most important to many of you is that she has participated as a member of the delegation of the Republic of Korea in the BBNJ negotiations from the very first preparatory committee in 2016 to its conclusion in 2023. So we welcome you. Ms. Jung, please, you have the floor.
Thank you, Judge Brown, for your kind introduction. Good afternoon, everyone. I'd like to start by expressing my sincere gratitude to the organizers of the conference. I think it is such a privilege to participate in this session and share insights and thoughts on this remarkable issue with all of you. In this year, more than 40 years after the adoption of UNCLOS in 1982, which was the year I was born, the third implementing agreement of UNCLOS, the BBNJ agreement, has been adopted. The BBNJ agreement is the first global multilateral agreement aimed at the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction. The BBNJ agreement was finalized after many years of negotiations and coordination from the establishment of the ad hoc open-ended informal working group in 2004, followed by meetings of the Preparatory Committee and the Intergovernmental Conference, IGC. I participated in the negotiations as a member of the Korean delegation from the first Preparatory Committee to the fifth IGC. Unfortunately, I couldn't participate in the 5bis IGC, where the negotiations concluded. I heard that during the final IGC, negotiations related to capacity building and transfer of marine technology were conducted intensely right up until the last stage. Throughout the IGC meetings, we often compared our negotiations to paddling a canoe. In order for the canoe to move forward, everyone must paddle together without leaving anyone behind. Riding together in this small boat symbolized our collective destiny and a mindset of being colleagues, motivating us to navigate through the negotiations with a shared sense of purpose. Since my colleagues have thoroughly covered the main points in their presentations, I'd prefer to provide additional points rather than comments or questions. Let me begin by one question. Why do capacity building and transfer of marine technology matter within the context of the BBNJ agreement? The purpose of the BBNJ agreement is to conserve and sustainably use of marine biological diversity in areas beyond national jurisdiction, ABNJ. Given its focus on marine biological diversity in ABNJ, cooperative efforts among states become imperative for its conservation. Achieving this objective may only be possible through international collaborative endeavors. Furthermore, as the agreement aims to manage and regulate activities in ABNJ, each country's scientific, technological, and administrative capacities are of utmost importance for its implementation. However, in reality, there might be disparities in the capacities and technological levels among countries. In this context, capacity building and transfer of marine technology can be regarded as a crucial issue when it comes to the conservation and sustainable use of marine biological diversity of ABNJ. For this reason, during the negotiation process, it was extensively discussed as one of the package. As Ms. SOTO mentioned, in the early stages of BBNJ negotiations, a major point of debate was about the nature of CBTMT, whether it should be mandatory or voluntary. Article 266 of UNCLOS stipulates that states shall cooperate to promote the transfer of marine technology and shall promote the development of marine scientific and technological capacity of the developing states. These are broad and ambiguous standards of behavior with specific legal obligations. In line with these UNCLOS provisions, developed countries, including Korea, wanted to maintain this approach within the BBNJ agreement as well, asserting that CBTMT should be carried out voluntary basis according to mutually agreed terms and conditions. On the other hand, developing countries advocated for activating and strengthening obligations related to CBTMT, aiming to fill the gap in UNCLOS and pushing for mandatory CBTMT. Due to these conflicting positions, negotiations were initially stuck, but after several rounds of discussions and negotiations at the IGCs, a landing zone was eventually found. This landing zone was reflected in Part 5 of the BBNJ agreement. Ultimately, the strength of obligations does not significantly surpass that of UNCLOS, as can be observed in expressions such as shall cooperate, shall ensure, within their capabilities, and shall promote and encourage in Articles 41, 42, and 43. As Dr. LOTHIAN mentioned, this could be seen as a choice aimed at allowing more countries to participate in or implement the BBNJ agreement. Nevertheless, the BBNJ agreement is highly commendable for making CBTMT aspects more specific, thereby enhancing the workability and meaningfulness of CBTMT under UNCLOS, aligning with its original goal of bridging gaps remained in UNCLOS. I think we can talk about a few key points, focusing on provisions within the BBNJ agreement. Firstly, the BBNJ agreement provides a clearer picture by detailing specific cooperation obligations in Article 41 compared to Article 266 of UNCLOS, and explicitly outlines CBTMT modalities in Article 42 and 43. Also, it introduces different CBTMT types in Article 44 and Annex 2, allowing further development through the future CAP sessions. Additionally, it has a clearinghouse mechanism for CBTMT implementation. Article 51 encourages information sharing and enhances access to marine technology through this mechanism, fostering collaboration among governmental, non-governmental, and private entities in CBTMT efforts. This tool is vital, considering the multilateral nature of the BBNJ agreement. Moreover, the agreement establishes a monitoring and review system for regular CBTMT assessment. A separate CBTMT committee will conduct this, requiring member states' reports. This mechanism aims to strengthen CBTMT, aiding countries, especially developing states, in implementing the BBNJ agreement effectively. By making recommendations and reporting to the CAP, the committee would enable the CAP to take appropriate actions. Lastly, the BBNJ agreement sets up a financial mechanism for CBTMT. Article 52 allocates the Special Fund and the Global Environment Facility Trust Fund for capacity building projects and technology transfer activities. Considering these aspects, the BBNJ agreement goes beyond the ambiguities and generalities of CBTMT in the existing obligations under UNCLOS. It thoroughly details the entire process of CBTMT, including demand identification, financial support through a dedicated mechanism, the modalities and types of CBTMT, transparent sharing of CBTMT-related information through clearinghouse mechanism, monitoring and review by the CBTMT committee, and actions by the CAP. This comprehensive delineation enables more concrete and meaningful cooperation and effective regulation, making it a more progressive agreement compared to UNCLOS, addressing CBTMT in a more advanced manner. The BBNJ agreement reached consensus after lengthy negotiations and compromises, can be recognized as a well-balanced agreement that does not undermine UNCLOS while providing more detailed obligations for countries in respect of CBTMT. It aims to promote and activate CBTMT in a direction that fosters a balanced approach. As I mentioned earlier, the international community's collaboration for the conservation and sustainable use of marine biological diversity in ABNJ is crucial for the effective implementation of the BBNJ agreement. Such international cooperation and coordination should take place across all levels, involving states, IGOs, NGOs, private sectors, and more. It's important that collaboration spans these various entities to tackle the challenges we face today. And these collective efforts allows us for a holistic and comprehensive response to the global issues. In this regard, one of the most remarkable aspects during the negotiations of the BBNJ agreement was the role of non-state actors, including NGOs. Their involvement allowed many delegations, including me, to grasp scientific knowledge and environmental perspectives that we might not have considered. These non-state actors facilitated negotiations to find a balanced path between conservation and sustainable use, bridging gaps in countries' positions when negotiations stalled. Especially during the 2 years when the IGC couldn't convene due to the spread of COVID-19, various online intersectional dialogues were organized. These platforms made us to understand the viewpoints and positions of diverse stakeholders, even though participating in late night or early morning online meetings from Korea was quite challenging. Also, I believe that non-state actors will continue to play an important role in expediting the entry into force of the BBNJ agreement by encouraging countries to ratify it. While it's difficult to predict the exact course of implementation and operation of the agreement at this stage, I believe that the implementation of CBTMT provisions will play a crucial role in the success of the BBNJ agreement. Learning from lessons and addressing any issues during future implementation will be essential to uphold the fundamental spirit of CBTMT, namely inclusive, equitable, and effective cooperation, requiring international efforts to ensure all participating countries effectively adhere to the agreement. Last October, Korea became the 83rd signatory to the BBNJ agreement by signing it. While domestic procedures and legislation for ratification remain, efforts are underway to ratify the agreement at the earliest. Preserving marine biodiversity in areas beyond national jurisdiction stands as one of the important obligations for the current generation, for the benefit of the generations to come. I hope for the rapid entry into force of the BBNJ agreement to aid in fulfilling this obligation. Thank you for your attention and the opportunity to be part of this discussion. Thank you.
Thank you very much, Ms. Jung. And you made the point about giving us further insight into the negotiating process from a developed versus developing country perspective. So that's an additional dimension, and we really thank you for that. You also mentioned, I believe, that you're born in 1982. That's what you said? Yeah, I mean, I kind of, you know, I braced, but I would say this, that the topic is law of the sea for the next generation. And it made me reflect on the fact that in 1982, when the UNCLOS was being adopted, it inspired me to do my PhD in law of the sea. And that the topic is so apt, because BB&J will likewise be inspiring a whole generation of lawyers and others to focus on this new agreement. Now, UNCLOS is the Constitution of the Oceans, and BB&J is the beginning of a new life. We're not sure where it's going to go. And on this issue, before I start thinking of your questions, because I'm about to throw it open to you, but on this issue, and I think you mentioned it, Harriet, that UNCLOS was very ambitious with transfer of technology until we got to 1994. You know, there the ambition ended. And so the key is, they say the proof of the pudding is in the detail, but the proof of the pudding is in the eating, and it's in the implementation. So we have that to see. So before we throw it out, at least I'm not before we throw it, this is the throwing out now. So, oh, and we see the president, and we see other hands. I don't have on glasses. So please, I'm seeing, oh, this is fantastic. Some people did read, or you did listen. Okay, so one, and then the president, please, and someone, okay, all right, please start. No, you have the mic first, so please go, and then the president.
Thank you very much for a wonderful panel. Yesterday we were talking a lot about Article 8.2 and the obligation for parties to the BB&J to promote the objectives of the agreement and other IFBs. Do you think that also applies to the obligation to ensure capacity building?
Can you pass the mic to the president, please? No, I wasn't speaking. Oh my goodness, I was not speaking. No, I wasn't being beyond myself. Please, President.
Thank you for yet another excellent panel. Judge Brown, you have made my life easier because you made a very provocative confession earlier about the lack of reading a certain chapter. So now I can make a provocative question following up on your example. So you may recall that Judge Peck in his keynote yesterday referred to the fact that because of the, or his opinion that because of the emphasis on the areas beyond national jurisdiction now for quite some time, perhaps one could argue that the areas within national jurisdiction had been neglected as a consequence. And perhaps there was even a stronger need to address some of the issues closer to the coast, where there may be even more problems in terms of pollution and IUU fishing and so on. So, and then I heard Dr. Harden-Davies talk about what are the needs of the party, or of the developing states. So I'm just wondering whether we could find the same kind of whether this would apply also to capacity building to some extent. And just so I'm thinking when we are talking about building capacity, for example, to do research with respect to marine genetic resources on the deep dark seabed, and to utilize those resources in the future, whether this may perhaps only, at least this part of capacity building under this agreement, may only apply to the more developed of the developing states. Because if we take an example of a state that has not is not at a very developed level and is dealing with a huge problem of IUU fishing within its exclusive economic zone, and that state perhaps has no means of defending its own. It doesn't have a coast guard. It doesn't have any vessels of that sort. And perhaps one could argue then that the needs of that particular developing state are more fundamental in the basics of just defending its maritime area from illegal fishing, rather than to get capacity building in terms of utilizing very kind of futuristic resources such as MGRs. So obviously the capacity building within BB&J agreement will benefit states also within national jurisdiction to some extent. But I'm wondering if there had been any thoughts in this process of this problem, that perhaps for some states, the bigger problems are really not taken into account because of this overemphasis on areas beyond national jurisdiction for such a long period. We all know that states have limited capacity, and states, as the international community, has limited capacity. So when the United Nations is focusing on a particular issue, other issues may be neglected in the process. So, kind of a provocative question. Thank you.
Thank you, President Hyder. There was one other person with the mic. Yes, please go ahead.
Thank you very much, Judge Brown, and thank you to this fantastic panel for the stimulating discussion. I know that this question of, whether it's a sleeping giant, as Sarah put it, has been awoken. And as Harriet said, some considered it the easiest to negotiate and the hardest to implement. So coming back to that element, and I do know that for those who weren't there, the CBTMT section was the first section that was concluded. I don't know if that was because it was easy to negotiate. I put it up to the skill and capacity of the very able facilitator. But it often comes back to a notion of unfulfilled promises and unmet commitments, which is how the situation occurred with UNCLOS, and I dare say in other areas of development discourse at the UN. So the questions that I have relate to when and how and by whom will CBTMT be initiated, including starting from and for needs assessment, and is there any scope for some of that work to be done pre-entry into force? And also, what of the existing cooperation that currently goes on now? Is it possible that we can start to catalog these as part of the BBNJ's CBTMT? Not that we want to take the credit for it, but start to put it under the BBNJ's rubric so that it starts to show a momentum towards success, and that we don't fall into the category of not implementing our CBTMT commitments. Thank you.
Thank you. I think this is given enough to begin. If we have time, we'll have a second round. But who wants to start chomping at the bits? Please, go ahead.
Thank you, Madam Judge Brown, Madam Moderator, and also I forgot to mention it's a huge honor to be in this panel with you. And also thank you for your questions. I stand to be technically corrected by experts here in our panel. Just to give a general overview on the answers. On the ABMTs and the relations to IBFs as well, it was part of the general purpose of the chapter to have an interrelated operationalization of its objectives. And indeed, having a cross-cutting approach in that regard, it was very important. So I would have to understand in that sense that it will have to be linked. It is very important and crucial. On the issue raised by Judge Hayder, indeed, it is actually it's a very particular question, because we do have to face that, and not only in this process of BBNJ, we face it in sustainable development negotiation processes. The premise to understand that there are different levels of characterization and different levels of development, even within regional groups, for example, the G77 and China. And that itself created a challenge also from delegations of this group, how to encompass a balance of positions. For example, there were positions that were more aligned to the fact that, for example, talking on transfer of technology, some countries do not have even a development of technology. They do not even have a technology, marine technology to implement, to transfer. And this was also very important on how to ensure their interests were protected, and that's why the country-driven approach was very important in this part of the agreement, because it is to adapt and also to assess the needs and priorities of this country, and also the encompassing with the level of development that it has, vis-a-vis the levels of development of other parties to the agreement. And that's why I think the caveat of within their capabilities in the end got its way through. Before, the discussions were very polarized in the fact that, for example, developing states parties did not want the caveat because we understood, and sorry if I mentioned we, because I used to defend that position before. We understood it as something that was conditioned in the obligation. But in the end, we arrived into the conclusion that there was no utility to do this divisive approach of developing, rather having parties and on an equal horizontal manner, and there each of us could accede. But of course, part of that compromise was also reinforced by the many other ones that we reached in the additional modalities, the taking into account the interest of developing states parties vis-a-vis the protection of patents of all types of technologies. Is there any work to be done, Kurt? That is a very important question. It's actually, I sense that CBTMT committee or the idea, and I have to, and apologies, I forgot to mention it in my presentation, but I have to do a huge shout out to the Caribbean community that led this proposal within the negotiations, and in this regard, the institutional framework meant to give that pulse of action to the CBTMT chapter. And of course, there's a lot to be done, like, for example, deciding the terms of reference, and I think this is one of the challenges that the members parties have to do, but also more procedurally now, we need a mandate, a trigger mandate, a procedural mandate from the General Assembly, being an intergovernmental body, to create that preparatory committee for the COP. So unfortunately, it will take a bit of time, but still, when we reach the COP, that I think one of the first immediate actions that we have to do is the CBTMT committee, and also to safeguard the relations of this committee with along other structural bodies created in the agreement. I'm
going to ask others to take a jump on it, but also getting back to President Haider's question, one of the things that struck me, and you can please comment on this as well, is, for example, in EIAs, where you have to do an EIA if you have dealing with a matter within national jurisdiction, which affects areas beyond national jurisdiction. CBTMT must then assist within areas within national jurisdiction. So that was, I think, part of President Haider's question about to what extent will CBTMT address developing countries' needs in tackling matters within national jurisdiction. And I know that we're coming to a close. I see the angel hovering behind me. So I'd ask everyone to give their last chomp on the 3 questions that we received before closing, sir. Okay? Please, everyone, go ahead.
Thank you so much. I'm going to give myself less than 1 minute and say let's talk more over coffee. Judge Haider, my thought is that rather than distract from areas within national jurisdiction, the BBNJ agreement could greatly assist with capacity building and tech transfer for areas within national jurisdiction, because the capacity resides in people. The technology is not only applicable beyond rather than within. A lot of small island developing states and other states have lots of deep sea right in their backyard. So there's a lot of different ways in which that technology is multi-purpose, and I can give some examples over coffee and cake with great pleasure. And then secondly, Mr. Kurt Davis, yes, let's talk some more. But I think that one of the things I would say in terms of can things be done differently and how, I'd give one example from a colleague recently who said that they are so determined to walk the walk as much as talk the talk that they've actually recently turned down a proposal to come and do a cruise in the waters because it's too business as usual. It's not doing things the way they want to do things differently under the UN decade and others. And I think we're seeing so much change in practice that what we now have on paper in the BBNJ agreement is coming up to speed with where things are in practice. So I think there's a lot of reasons to be hopeful and lots we can do. And I'll pass over to my colleagues now and look forward to chatting more over coffee.
Thank you for your question, Judge Haider. I was actually lucky enough to participate in that wonderful regional workshop that Lisa spoke about earlier. And one of the things I really felt from that was the ways different states reps were coming together to collaborate. And I think that there's a real opportunity to use BBNJ discussions as a platform to discuss national issues. So I can see that going forward, and I think that's a way that we can collaborate on those issues. And I think events like this, webinars, workshops, bringing different countries together to address the issues is where you're going to get that discussion going. And I think that could greatly assist in terms of capacity building. I'll tackle Joanna's question. I think I agree with Ligia. I think the answer is yes. I think if you read it in conjunction with the objectives of the instrument, you're looking at the general objectives in Article 2, but as well as those specific objectives in Part 5, I definitely think it would be applicable in the IFB context. So I hope that helps. I'll stop there.
There is nothing to add to the previous speakers, so I think we should have coffee now.
Thank you very much. I must admit that every moderator so far in the past 4 sessions had made my job much easier, so I appreciate that. And once again, ladies and gentlemen, please give a big round of applause for our moderator, Judge Brown, and also our fabulous speakers up on the stage.